Welcome to this bite-sized update on understanding the challenge process under the new Procurement Act. I'm John Haney. I'm a partner at TLT. I'm a commercial and public law litigator. I was first involved in a procurement challenge about 13 years ago when I acted for Leeds City Council in relation to a challenge involving the development of a new arena in Leeds. Having dealt successfully with that case, I became more and more involved in procurement cases, and now I act for both central and local government and for aggrieved contractors and suppliers. I currently spend about 70% of my time dealing with procurement challenges. Because I've worked on both sides of the fence, I have a good understanding of how an authority may react to a challenge, how the authority will be thinking, and what it's likely to do in certain situations. I also understand the motivation of a contractor and what they may wish to achieve and how best to go about that. And it's the challenge process under the new Act that I will discuss today. Moving on now to the agenda. We'll be looking at the following 5 points today. When can you bring a challenge? What is the process and timescale? What information should an authority provide? What are the available remedies? And what's the role of the procurement review unit? When can you bring a challenge? The position remains that a supplier can bring a claim if they've suffered or at risk of suffering loss or damage as a consequence of a breach of the duties provided for in the Act. We'll come on to discuss the sort of breaches which may give rise to a claim, but in terms of who can bring a claim, at its simplest, a supplier which participates in a tender and is either excluded or is unsuccessful in the procurement in circumstances where there's been a breach of the duties in the Act can bring a claim if it can show that were it not for a breach, it would have won the contract. Alternatively, if a contract is awarded without there being a competitive procurement process, a supplier can challenge the award, again, provided it can show there's been a breach of the duties in the Act, and that were it not for the breach, it would have won the contract, or at least had a reasonable chance of winning the contract. The other points to note on this slide are that a supplier can only bring a claim in relation to above threshold procurements. Some procurements are excluded, such as, for example, defence and security contracts, and it doesn't apply to some specific breaches around SMEs and having regard to procurement policy statements. In this slide, we explore the circumstances in which a supplier may choose to challenge the outcome of a procurement. We thought it was worth discussing this as we appreciate that instinctively it may feel odd to threaten to sue a public body which may give you the lion's share of your work, or which is a major customer in your sector or locality. Suppliers don't want to get a reputation as troublesome or difficult to work with, and they don't want to challenge to prejudice their chances in future tenders. And those are all understandable concerns. However, those concerns are not borne out in our experience, and in reality there are many good reasons why a supplier may choose to challenge the outcome of a procurement, even if it is that it's simply an informal challenge which involves asking a series of questions, as this can quite often lead to a positive outcome for the supplier. We find that the main drivers for bringing a challenge are usually one or more of the following. The contract in question may be the supplier's main contract. It provides a disproportionate percentage of its revenue and/or it's a high-profile contract, and losing it will have a significant financial and reputational impact. In those cases, a supplier may feel that they have no alternative other than to challenge the decision, even if it's just a case of trying to get a settlement out of the challenge or extending the existing contract. On that point, where the supplier is an incumbent, for reasons I'll discuss shortly, a challenge can delay the authority entering into the new contract, and they may be forced to extend the current contract. So there's an added incentive for an incumbent to challenge, and to some extent, the legal costs of a challenge may be offset or even dwarfed by the additional profits and continuing the existing contract for, say, an extra 3 to 6 months. We mention in the table the disclosure process providing insight into competitor behaviour. This is a really important point, and I have a number of clients who have used the threat of a challenge to obtain greater detail about the authority's rationale for its decision than it would typically receive in the outcome letter. Now, there are changes on the new Act which may lead to a greater transparency and a better level of detail about why a supplier was unsuccessful and why the winning bidder scored higher. But historically, the quality of feedback has varied enormously from one authority to another. It can often be fairly limited, and it remains to be seen if the position under the new Act will improve to any great extent. By raising concerns about the approach to the evaluation and at least hinting at the potential of a formal challenge, suppliers have obtained copies of, for example, the moderation and evaluation notes maintained by the authority. These are usually some of the key documents recording how the decision was made. By accessing these documents, a supplier is able to really get beneath the surface of where they've gone wrong, so they can improve their bid writing in the future, and perhaps more importantly, they can get a better feel for how and why their competitor has scored higher. We're mentioning in the table procedural errors and manifest errors, and the point we're making there is that sometimes it's very clear that there's been an error from a procedural point of view, and to take an obvious example of that, the authority has added up the scores incorrectly, or there's a manifest error in the approach to scoring, which I'll discuss in greater detail shortly. In those circumstances, it would seem odd not to raise the issue with the authority, to point out the errors of their way, give them a chance to consider and put it right. That may involve the authority re-evaluating or abandoning and starting again. You may feel that there isn't much chance of that, but from our experience of advising authorities, where a clear error has been made, and it doesn't have to be as stark as my example of an incorrect adding up, if you can explain where they've gone wrong and it affects the outcome of the procurement, we usually see the authority agreeing to remedy the situation. The letter to the authority can be very polite, can be matter of fact, and indeed, those are often the most effective letters. Conversely, where we're acting for an authority, we often see very aggressive letters accusing the authority of all sorts of breaches, asking for the kitchen sink in terms of information, but with very little substance to the claim. An authority is more likely to push back against that sort of letter as opposed to a polite, matter-of-fact note identifying obvious errors. We mentioned the reputation of the authority in the slide. Ultimately, these claims can end up in open court, in which case they are reported on publicly. And most authorities are keen to avoid that sort of press coverage. If they've made an obvious error, and that background can be a motivating factor in bringing a claim. Finally, if a supplier is a large organisation and it has a big in-house team, it may be better able to resource a full-blown legal challenge. I make that point as it's important to note that these claims, if proceed to a full-blown legal challenge, take up a lot of management time, and the legal costs can be significant. Having said that, it's the same for the authority, and that will be a consideration for the authority when it decides how to react to a challenge. In the next two slides, I'll discuss some of the common grounds for bringing a challenge. This is not exhaustive, but it covers the main issues we see regularly and which are worth looking out for when considering the feedback provided. Issues in relation to the procurement itself. Sometimes there's an issue in relation to the clarity of evaluation criteria and how it's applied by the authority. In the healthcare at home case, the Supreme Court had to consider a tendering process in respect to the provision of medical services to health authorities. Healthcare at home challenged the authority's decision, saying that the criteria in the invitation to tender were insufficiently clear and that the reasons given to it for the rejection of its tender were unclear and lacking in detail. The Supreme Court found that the test to apply in these cases is whether criteria are sufficiently clear to satisfy the duty of transparency and equal treatment. This is an objective test, and the question is, would a reasonably well-informed, normally diligent tenderer interpret it the same way as the authority? If, objectively, the authority has adopted a different approach to that of the reasonably well-informed tenderer, then there may be a basis for a challenge. The next bullet point is failure to apply criteria correctly or the introduction of undisclosed criteria. We frequently see in feedback letters references to reasons for increasing or decreasing scores based on criteria which are not in the ITT. So it's worth considering whether the authority applied a criterion which is not in the ITT. If it did, the decision may be unlawful. Or did it fail to take into consideration one of the criterion? Same again, that may be unlawful. Sometimes we see the use of model answers. For example, when the suppliers are asked to respond to a case study scenario, the authority may have developed a model answer, which sets out what it expects to see in a good answer. However, if that model goes beyond a generic discussion of obvious points it expects to see and effectively creates a checklist above and beyond the published criteria, it may well amount to an undisclosed criteria. It's worth asking in this type of situation whether the authority has used model answers to test out this issue. The final one on this point is that an authority in its feedback may say that some aspects of the winning bidders tender were better than the challengers in some respect and therefore scored higher. So they are effectively comparing the bids, and that's not part of the scoring matrix and amounts to the introduction of undisclosed criteria. Again, that may well be unlawful. And turning to the last bullet point on this slide, manifest error. There's a fair amount of case law on this. In summary, it's clear that an authority has what's called a wide margin of appreciation when carrying out an evaluation of bids. In other words, the court will be slow to undermine or interfere with the views and decisions of the authority's subject matter experts. It appreciates that the authority is best placed to determine what is the best solution to meet its own requirements. However, sometimes the evaluation process is so obviously wrong, it's so manifestly wrong, that the court will interfere and effectively start to change the scores awarded. The first reported case of that type was Woods, where the court found manifest errors to such an extent that it set aside the decision to award the contract. My own crude test on this is, does the error leap off the page? Is it very clearly wrong? It is a high hurdle, but sometimes it is possible to demonstrate that to be the case, as in the Woods case. Continuing on the common grounds of challenge, the next one to mention is failure to follow process. This is where the authority doesn't follow its own published process. It misses out or changes a stage of the process. An example of this is a client who had a moderation stage in the procurement and decided it wasn't worth doing the moderation as the outcome was clear. That may be their firm and genuine view, but they shot themselves in the foot by failing to carry out a stage they expressly said they would carry out. Next bullet point is lack of transparency. We're looking here at the failure to maintain adequate records of decision making and/or a failure to provide reasons or adequate reasons for a score. The point is well made in the quotation from the case cited in the slide. A procurement in which the contracting authority cannot explain why it awarded the scores, which it did, fails the most basic standard of transparency. It's not uncommon for there to be a disconnect between the authority's internal evaluation documents and the reasons for the award set out in the outcome letter. This emphasises the importance of getting hold of the authority's evaluation documents, which I'll come on to shortly. And the final bullet point here is the exclusion of bidders. We're looking at here, for example, missed deadlines. A recent example was that in the in-health intelligence case. It was a not unusual tale of woe where the supplier had got into trouble uploading the tender and had failed to do so by the deadline. Predictably, they were excluded, and whilst they challenged the exclusion, the authority's decision to exclude was upheld by the court. That said, the authority usually retains the discretion to allow in a late bid, but it has to be careful about the exercise of that discretion, particularly if the reason for the late submission is down to problems with the portal or the authority's own IT. Bringing a formal procurement challenge is not straightforward due to the very tight timescales involved in bringing a claim. It's easy to lose a chance by missing a deadline. Unlike a simple breach of a contract claim, where a supplier usually has 6 years to bring a claim, if you want to prevent the authority from entering into a contract, you need to do that within the standstill period, which is now 8 working days from when a contract award is published and within 30 days of becoming aware of facts which could give rise to a claim. A situation where I've seen suppliers miss out on a possible claim is where an issue arises during a competition, but the supplier waits until the outcome letter is issued. Once the supplier is aware of an issue which may give rise to a claim, it has 30 days to bring a claim. If it doesn't do that in time, then it could well be precluded from bringing a claim. The authority would defend a claim on the basis that it's out of time. On more than one occasion, I've advised suppliers who had good grounds to complain about an authority's conduct, but they only came to see me after the outcome of the procurement was announced. More than 30 days had passed since the issue had arisen, and had to break the bad news to them that they'd missed the chance. I appreciate that it's a difficult situation. A supplier doesn't want to sour relationships mid-competition by threatening to sue the authority, but it may be the only way to preserve the supplier's legal rights. In any event, it's worth remembering that if that situation does arise, speak to your lawyers. There are potential solutions. Assuming no issues mid-competition, the authority issues an assessment summary which sets out the reasons for the scores and those of the winning bidder. We discussed the summary in greater detail in another bite-sized session, but the summary should be more informative than a standstill letter under the old Act. But worth noting that the assessment summary is sent out independently of the contract award notice, which is a document which now starts the standstill period running. So a supplier may receive the reasons for the award and the contract award notice at different times. In our experience, most suppliers are interested in winning the contract. They want the chance to perform the contract. The alternative is a damages claim for lost profit, but what they really want to do is overturn the decision and for the authority to award the contract to them. With that in mind, if proceedings are issued before the contract is entered into, i.e. within the standstill period, then the authority is automatically prevented from entering into the contract. The power to enter the contract is suspended. If the authority has already entered into the contract, then the supplier has probably missed its chance to win the contract, and the supplier will only get damages. So there is some importance in issuing before the contract is entered into. That said, the authority can apply to court for the suspension to be lifted, and I'll come on to that shortly. In any event, if a supplier wishes to bring a claim for damages, it has to issue proceedings within 30 days of having knowledge of facts giving rise to a claim. Theoretically, the court can extend this by up to 3 months, but in reality, it's exceptionally rare that it will do so. The message is that if a challenger has to get on with it and has to have a very close eye on the key dates. There are certain circumstances where the court can set aside the contract even after it's been entered into, which I'll discuss in the remedies section. It's equivalent to the declaration of ineffectiveness under the current Act. In those circumstances, the time limit for bringing a claim is 30 days, beginning with the day on which the supplier first knew or ought to have known about the circumstances giving rise to the claim, or the end of the period of 6 months, beginning with the day the contract was entered into or modified. It's a feature of the procurement process that the authority holds all the information about how it conducted the evaluation and all the data which sits behind that. The supplier only receives a summary of how the authority reached its decision. That being the case, it's very difficult for a supplier to make an informed decision about bringing a claim without obtaining further details of the decision-making process. Added to that difficulty is the fact that the supplier has a very short period of time to bring a claim. The courts have recognised that fact and in various reported cases and in issued guidelines have made it clear that it expects authorities to act reasonably in providing early disclosure of key decision-making documents to a challenger to enable them to determine whether they have grounds for bringing a claim. This can include moderation and evaluation notes and training guides and the tender report prepared by the authority. This is not a hard and fast requirement. An authority may resist handing over everything initially, and it will certainly be reluctant to hand over the notes relating to the winning bidder, but it should be possible to obtain at least some of those documents pre-issue. It may be necessary to ask the authority to extend the standstill period to allow a supplier a reasonable opportunity to consider those documents, which an authority can and should do. Once the claim is issued, the claim will eventually reach a stage where both parties will be required to provide full disclosure, which will include all documents which either help or hinder each party's case. This is a very broad requirement and importantly will include the winning bidder's tender, internal meeting notes and communications, including emails, WhatsApp and team messages, for example. These can sometimes be very revealing in terms of how the authority went about the process, but in my experience, the value can be overstated. Some of the documents disclosed by the authority will include confidential information relating to the winning bidder. In those circumstances, the court manages that by the parties entering into a confidentiality ring, where those included in the ring give undertakings to the court not to use the information other than for the purposes of the proceedings and not to share the information outside the ring. Who is in the ring can be quite contentious. It's usually okay to have external lawyers in it, but the winning bidder may object to representatives of the supplier seeing its confidential information. But on the other hand, the supplier will struggle to give instructions to its lawyers if at least one representative is not in the ring with sight to the information which is being provided. I'm now going to briefly look at the litigation process itself. The broad shape of the litigation is the supplier issues its claim in the High Court. It tells the authority it has issued the claim, and it has to file detailed particulars of the claim within 7 days of issuing the claim, which is very challenging. Then the timetable rolls on with the authority filing a defence. There will be a case management conference at which the timetable to the trial will be set. There will then be disclosure, which I've already discussed, witness statements, and ultimately a trial. The process takes about 10 to 18 months from start to finish. It may be possible to persuade the court to expedite the proceedings and get it heard sooner, but that's a typical timeframe to have in mind. The bit of the timetable I didn't mention there is lifting the automatic suspension. As noted earlier, the issue of a claim within the standstill period brings about the automatic suspension. That stops the authority entering into the contract. However, the authority is likely to be very keen to get on with sorting out its new contract. It may be imperative to continue a certain service. With that in mind, the Act allows the authority to apply to lift the automatic suspension. This had been a key battleground between suppliers and authorities over the years, and much of the case law relating to procurement challenges involves an application to lift the automatic suspension. It's probably fair to say that we've reached a stage that, save for a limited number of cases, it's likely that the court will lift the automatic suspension and allow the authority to press on with the contract, as the authority will be able to show that the supplier can be adequately compensated with an award of damages, i.e. recompensing it for its loss of profit, even if it wins the case. So it's more likely than not that the authority will be allowed to enter into the contract. In that case, the supplier is left with its loss of profits only. That may still be a valuable claim, but it may not be what the supplier wanted. In my experience, a supplier may lose interest in a case if it's left with a loss of profit claim and the prospect of a 12-month slog to trial. That being a well-advised authority will be keen to make an early application to lift the suspension. I should highlight that the new Act has introduced a new test for the court to consider when determining if the suspension should be lifted. The test now involves the court considering the public interest in, among other things, upholding the principle that public contracts should be awarded in accordance with the law, avoiding delay in the supply of goods, services, or works provided for in the contract, the interests of suppliers, including whether damages are an adequate remedy for the claimant, and any other matters that the court considers appropriate. We don't know yet whether that will make any significant difference to the court's approach on this. The only other point I'd note on the timetable is that we've included mediation. Most cases will involve mediation or some form of without prejudice attempt to settle the claim. The courts are becoming increasingly keen to ensure that parties attempt to settle cases, and I have to say that in my own experience, mediation can be a very effective tool to bring about an early conclusion to a dispute without the need for a trial. Turning to remedies, I've already discussed some of the remedies, and in particular, I mentioned the automatic suspension and the ability to lift or modify it as an interim remedy. As I mentioned in the context of manifest error, before a contract is entered into, the court has the power to set aside the authority's decision. That usually means that the authority will be required to go and re-procure or make alternative provisions for meeting its needs. Alternatively, the court can award damages. Usually that means the court will assess the supplier's loss of profit to put it in the position it would have been had it won the contract. So it's not the lost turnover that court looks at, but its net profit. It's sometimes not straightforward assessing lost profit, particularly when a framework is involved, as there may be no guarantee of work from the framework, but the court will do its best to assess what the supplier has lost due to the breach. As I said earlier, a supplier quite often wants the chance to deliver under the contract, so damages may not be ideal. Once the contract has been entered into, the court is limited to awarding damages unless it's satisfied that the supplier was denied a proper opportunity to seek pre-contractual remedy because, for example, a required contract award notice was not published, or the contract was entered into before the end of an applicable standstill period, or the contract was entered into during a period of automatic suspension. In those situations, the court must set aside the contract or shorten the contract and may award damages. Finally, I'll say a few words about the Procurement Review Unit, which replaces the Public Procurement Review Service and the Mystery Shopper. The PRU's ambition is to raise standards in public procurement, driving accountability for contracting authorities and suppliers in the UK. The PRU will focus on investigating systemic and institutional non-compliance issues in response to complaints from suppliers. An investigation by the PRU may involve reviewing information and/or speaking with individuals involved in procurement to understand the cause of compliance issues. Authorities must provide any documents requested by the PRU within a stated timescale, which is a minimum of 30 days. Subject matter experts from outside the PRU may also be consulted to ensure appropriate recommendations are provided. Findings and the recommendations will then be captured in a report, which may be published. The authority must have regard to any recommendation by the PRU, so that doesn't mean that they have to follow it. That said, the PRU can require an authority to provide a progress report. A referral to the PRU cannot be used in conjunction with other legal remedies, for example, a formal legal challenge. It remains to be seen how effective the PRU will be, but it's worth noting that it's there, and we've included links to some guidance notes in the slides. Thank you for listening to this bite-sized session today. If you have any questions, do not hesitate to contact me or any of my colleagues. Finally, just a quick plug about our Procuring 360 initiative, which is TLT's support package for both CAs and public sector suppliers in terms of getting ready for the new Procurement Act 2023. We are able to offer a range of support, not just legal, but also technical, consultancy, and more practical support. So do check out our website or contact one of the members of the team if you require any further support in relation to getting ready for the implementation of the new Act. Thank you.